Okay.
start, and then also.
When you need to stop.
When you stop, and then also remember doing your Q&A to turn it
Oh, okay, okay,
because it does pick up.
okay. All right, the Subcommittee on Workforce Protections will come to order. Welcome, everyone. I note that a quorum is present. Representative Joe Morelli of New York will be participating in today's hearing with the understanding that his questions will come only after all members of the Workforce Protection Subcommittee on both sides of the aisle who are present have an opportunity to question the witnesses. Without objection, so ordered. The subcommittee is meeting today in an oversight and legislative hearing to hear testimony on evaluating the Department of Labor's efforts to undermine strong overtime protections. Pursuant to Committee Rule 7C, opening statements are limited to the chair and ranking member. This allows us to hear from our witnesses sooner and provides all members with adequate time to ask questions. I now recognize myself for the purpose of making an opening statement. Today, we will discuss the importance of strong overtime pay protections for American workers. Since the passage of the Fair Labor Standards Act in 1938, Congress has guaranteed basic overtime protections by requiring certain workers to be paid 1.5 times their regular rate of pay for any hours worked over 40 in a work week. As our witnesses will discuss, strong overtime protections help achieve 3 key goals. They protect workers from being forced to work excessive hours, they ensure that working extra time comes with extra pay, and they encourage employers to hire more employees rather than overwork current employees. Unfortunately, due to weak overtime standards, some employers are relying on a business model that shifts extra work normally done by workers with overtime protections to workers without overtime protections. This leaves some salaried workers who should be eligible for overtime working 50 and 60 hour weeks without an additional pay, and other workers with too few hours. While growing income inequality and the declining power of workers have only reinforced the need for strong overtime protections, the federal government has repeatedly failed to properly update overtime standards to keep pace with the economy. Under Fair Labor Standard Act regulations, salaried workers who earn below a salary level established by the Department of Labor are automatically eligible for overtime pay. In 1975, the Department of Labor set the salary level to $13,000 per year. That was equivalent to almost $58,000 a year when translated into 2020 dollars. At that salary level, over 60% of full-time salaried workers were eligible for overtime pay based on their salaries alone. 29 years later, in 2004, the Department of Labor under the Bush administration set the salary level to $23,660 a year. This is equivalent of about $33,000 a year in 2020. This salary level covered only about 13% of the full-time salaried workforce in 2004, compared with 60% back in 1975. The salary threshold was developed using a flawed methodology. Over the next decade, failure to update the salary level meant more and more workers were without overtime protections. In 2016, the $23,600 a year salary level covered fewer than 7% of the full-time salaried workforce. Recognizing this harmful trend, the Obama administration finalized a rule to raise the salary level to roughly $47,500 in 2016. This long overdue update would have extended overtime protections for 4.2 million workers, restored overtime protections to 1/3 of the full-time salaried workforce, put $1.2 billion into the pockets of lower and middle wage workers, and established automatic updates to prevent another lapse in overtime protections. In 2020, the salary level would have been approximately $51,000 a year. Unfortunately, a flawed district court ruling blocked the department from implementing and enforcing the rule. Rather than defending the Obama-era overtime update in court, the Department of Labor is now proposing a new, lower salary level of about $35,000 a year to take effect in 2020. The Trump administration's proposed salary level, based on a flawed methodology first used in 2004, would cover only 15% of full-time salaried workers compared to the 33% that would have been covered under the Obama rule. It would leave 8.2 million workers behind and deny American workers more than $1.2 billion in additional pay. The new proposal also fails to include automatic updates to the salary level, leaving salaried workers vulnerable to, once again, losing overtime protections in the foreseeable future. After more than 40 years, without an adequate update to the overtime rule, the Trump administration's proposals falls well short of what workers deserve. Despite the president's promise to fight for American workers, his administration continues to block federal policies that would lift working families into the middle class. Congressional Democrats stand ready to protect workers where the administration fails to do so. The Restoring Overtime Pay Act, H.R. 3197, introduced by Congressman Mark Takano, would codify the strong salary threshold set in the 2016 final rule and require automatic updates every 3 years to ensure the level remains in line with overall increases in workers' wages. Restoring workers' access to strong overtime protections, raising the federal minimum wage, and protecting workers' right to join a union are federal policies that would improve standards of living and stimulate local economies across the country. These three pillars are essential labor market institutions upon which working people rely. However, the Trump administration continues to oppose each of these efforts to give hard-working Americans a raise. Today's hearing is an opportunity to examine the federal government's responsibility to restore overtime protections for millions of workers. It is also a chance to discuss the importance of building an economy that works for all Americans, not just the wealthy few. I want to thank all of our witnesses for being here today, and I look forward to your testimony. I now recognize the distinguished ranking member for the purpose of making an opening statement.
Thank you, Madam Chairwoman, and hello and welcome to all the witnesses that are here. After clocking 40 hours of work, there are few incentives as attractive as overtime pay to motivate an individual to come back for more that week. The Department of Labor should make sure those entitled to overtime pay receive it, and the proposed overtime rule from the Department of Labor will help ensure that. But my colleagues on the other side of the gavel aren't hearing it. This spring, the Department of Labor published a notice of proposed rulemaking in the Federal Register, which raised the annual salary threshold to be exempt from overtime pay by over $11,000. This rule would make over 1 million additional American workers eligible for overtime pay. 1 million. So when I see the label for this hearing where it says DOL's efforts to undermine strong overtime projections, I see 1 million reasons why that statement is untrue. For some reason, this sensible proposal to modernize the overtime pay salary threshold doesn't make my friends on the other side happy. Rather than welcoming this exceptional opportunity, they would rather wallow in their partisan opposition to President Trump and oppose any and every policy coming out of his administration, even when the policies are as reasonable as this one. We're here today because, in stunts of political point scoring, the other side insists on revisiting the radical and discredited Obama-era overtime rule, which everyone should recall was invalidated in a U.S. district court. The Obama rule was invalidated in a U.S. district court. The Obama rule proposed to hike the threshold for exemption from overtime pay by over 100% to a salary of almost $50,000. As the court wrote in its decision in validating the rule, quote, "The department has exceeded its authority and gone too far with the final rule," close quote. A federal district court said that. In addition to being excessive, misguided, and unworkable, this spike wasn't projected to help workers in the long run. Young Americans would have been particularly harmed by the rule because it would have increased college costs and made it harder for graduates to begin their careers. We heard from a number of universities in the past 2 or 3 years that it would decimate their ability to offer services to college students. And that is one of the most important things we deal with on this committee is education. The Obama scheme would have resulted in fewer job prospects, less flexibility in the workplace, and less opportunity to move up the economic ladder. Small businesses, nonprofit employers, colleges and universities, and the people all these American institutions serve would have been hit the hardest by the Obama administration's rule. That's ironic, considering we presumably work on this committee to promote and protect these very sectors of our country. I want to remind my colleagues on the other side that the Department of Labor reached its salary threshold in the proposed rule using the same sound methodology as the Bush administration did in 2004, which sent the current minimum that we use today, $23,660. It is entirely reasonable and indeed wise in this time of economic growth to look at what has worked before. Instead of rebelling in political outcry, we would all serve America's middle-class workers well to take a step back and be objective about this. Times have changed, and the economy along with it. And this proposed rule is a responsible, reasonable, and workable answer in keeping with the purpose and historical level of the overtime salary threshold, and most importantly, in affirming the value of every American worker. Madam Chairwoman, to you and to everybody who's here today, I'm going to offer my apologies. I'm on another committee, the Armed Services Committee. We're marking up the National Defense Authorization Act today, and it may very well be that I get up and leave before the hearing's over to go vote in that committee. I'm not angry. I'm not put out. I really would rather be here, but I think it's important that I have my vote over there. So I want you to understand that I'll be back as quickly as I can if that occurs. And with that, I yield back.
Thank you. Thank you very much. Without objection, all of the members who wish to insert written statements into the record may do so by submitting them to the committee clerk electronically in Microsoft Word format by 5 p.m. on Tuesday, June 25th. I'll now introduce our witnesses. Dr. Heidi Scherholtz is Senior Economist and Director of Policy at the Economic Policy Institute. Dr. Scherholtz previously served as Chief Economist to the U.S. Secretary of Labor under Secretary Thomas Perez. Ms. Tammy McClutchan is a principal in Little Middleson's Washington, D.C. office. Ms. McClutchan previously served as Administrator of the Wage and Hour Division of the U.S. Department of Labor. Mr. Pete Weinbrake is the founder and managing partner of Weinbrake and Santillo, LLC, based in Dershire, Pennsylvania. Mr. Weinbrake has litigated hundreds of wage and overtime lawsuits in courts throughout the United States. I am pleased now to recognize my colleague, Representative Morelli, to briefly introduce his constituent who's appearing before us as a witness today.
Thank you, Madam Chairwoman, for the courtesy to a non-member of the subcommittee, allowing me a moment to introduce my constituent. I'm pleased to welcome to this Workforce Protection Subcommittee Ms. Ann Babcock-Steiner. Ann is an attorney and the Senior Vice President of Human Resources for Pathstone Corporation, a not-for-profit community development organization in my district of Rochester, New York. She previously served as a Deputy Attorney General for the Indiana Attorney General's Homeowner Protection Unit. In her capacity at Pathstone, Ms. Babcock-Steiner has provided comprehensive, holistic services to those in need, from workforce development initiatives, education, and health services to ensuring safe, stable housing. Pathstone helps create opportunities for individuals and families throughout our community. I'm so grateful to Pathstone for their many contributions to our community and for their continued commitment to advocating for stronger worker protections. And I'm particularly delighted that to have Ms. Babcock-Steiner here today. And I would ask my colleagues also to note that she is spending her birthday with us, and I wish her all the best wishes on another safe trip around the sun. So happy birthday, and thank you, Madam Chair.
And thank you, and happy birthday. We appreciate all of the witnesses for being here today and look forward to your testimony. Let me remind the witnesses that we have read your written statements, and they will appear in full in the hearing record. Pursuant to Committee Rule 7D and committee practice, each of you is asked to limit your oral presentation to a 5-minute summary of your written statement. And let me remind the witnesses that pursuant to Title 18 of the U.S. Code, Section 1001, it is illegal to knowingly and willfully falsify any statement, representation, written document, or material fact presented to Congress, or otherwise conceal or cover up material fact. Before you begin your testimony, please remember to press the button on the microphone in front of you so that it will turn on and the members can hear you. As you begin to speak, the light in front of you will turn green. After 4 minutes, the light will turn yellow to signal that you have 1 minute remaining. When the light turns red, your 5 minutes have expired, and we ask that you would please wrap up your testimony. We will let the entire panel make their presentations before we move to member questions. When answering a question, please remember to once again turn your microphone on. I'm going to first recognize Dr. Shearholtz.
Chair Adams, Ranking Member Byrne, and members of the subcommittee, thank you very much for the opportunity to testify here today. The overtime protections of the Fair Labor Standards Act are a crucial part of a vibrant middle class because they give employers the incentive to hire more workers rather than overwork existing employees, and they ensure that workers are fairly compensated when they are asked to work long hours. In the Fair Labor Standards Act, Congress provided overtime protections to most workers, but directed the Secretary of Labor to exempt a limited number of well-paid, bona fide managers, executives, or highly trained professionals, since these workers command enough bargaining power, enough control over their own work and schedules that they don't actually need the protections. For an employee to be exempt from overtime protections under this exemption, they must earn a salary, they must pass the duties test based on the actual work that they do, and they must earn above the salary threshold. The salary threshold can best be thought of as a bright line proxy for the duties test that simplifies the determination of exemption. It helps ensure that frontline supervisors who get relatively low pay and have little bargaining power are not taken advantage of, and it reduces the misclassification of non-exempt workers as exempt. In 2016, the department finalized an overtime rule following an exhaustive rulemaking process. That rule increased the salary threshold to roughly $47,000, which is the 40th percentile of earnings of full-time salaried workers in the lowest wage census region. However, a single district court judge in Texas held the rule to be invalid. And instead of defending this rigorously determined rule, the department under the current administration has proposed a new rule with a much lower threshold. The department's current proposal sets the threshold at roughly $35,000 in 2020, which is essentially the 20th percentile of earnings of full-time salaried workers in the lowest wage census region. So this is the same methodology that was used in the 2004 rule. Unfortunately, the methodology in the 2004 rule was fundamentally flawed. So historically, the department sets tests for overtime eligibility in one of two ways. It pairs a low salary threshold, which covers few workers, with a strong duties test, which covers more workers, or it pairs a high salary threshold, which covers more workers, with a weak duties test, which covers fewer workers. Both of those options create the intended balance, but in 2004, the department paired a low salary threshold with a weak duties test, and because of this erroneous mismatch, the methodology from the 2004 rule departs from decades of historical precedent and is fundamentally inappropriate. In 2016, the department corrected this error by keeping the same lenient duties test that was used in the 2004 rule, but correctly pairing it with a higher salary threshold. In fact, in 2016, the department picked nearly the lowest possible threshold consistent with historic precedent. According to the methodology that was used to calculate the thresholds from 1958 until the 2004 error, the department should have set the threshold in 2016 somewhere between $46,000, and $65,000. They chose $47,000. So a key thing this highlights is that while the increase in the threshold in the 2016 rule was large, it was only because it had been over 40 years since the threshold had been appropriately updated. At its core, the department's proposal is based on the notion that someone making $35,000 a year is a well-paid executive who does not need or deserve overtime protections. My analysis, which is using the exact same methodology that DOL does to look at their impacts, finds that 8.2 million workers who would have benefited from the 2016 rule will be left behind by the department's proposal. That includes 4.2 million women, 3.0 million people of color, and 2.7 million parents of children under the age of 18. And together, workers will lose $1.2 billion annually. Congress should step in and pass the Restoring Overtime Pay Act, which codifies the 2016 rule as a floor and upholds the purpose of the overtime provisions of the Fair Labor Standards Act. Thank you.
Thank you very much, Ms. Babcock Steiner. You are recognized for 5 minutes.
Thank you, Chairwoman Adams, Ranking Member Burns, and other members of the subcommittee for the opportunity to present at today's hearing. My name is Ann Babcock Steiner, and I am the Senior Vice President of Human Resources at Pathstone Corporation, a New York-based nonprofit with the mission of building economic self-sufficiency for families and communities. I'm honored to be here representing an employer that has a rich history of advocating for strong worker protections. Pathstone has about 600 employees in 7 different states and in Puerto Rico, who serve more than 41,000 individuals each year through our workforce, community, housing, and housing development programs. Back in 2016, when the Department of Labor proposed raising the salary threshold to $47,476, Pathstone was compelled to conduct a mission-based analysis to determine what this would mean for our constituents and for our employees. We concluded that we must support and implement the proposed salary threshold, and we remain firmly committed to this position today. A higher salary threshold has value to both employees and employers. As the department has noted, many non-exempt classifications can be made with the salary level test alone. While the classifications under the salary level test can be made with a quick payroll report, the duties test can be subject to multiple interpretations. Each exemption has a lengthy list of factors that must be analyzed, and this task goes far beyond an examination of job descriptions, work plans, and organizational charts. The law requires that we must examine what the employee is actually doing, and this process must be repeated every single time we make a program adjustment or a staffing change. Because the duties test is so difficult to apply in practice, the salary threshold becomes even more important. However, the value of the salary threshold is dependent on the level at which it is set, as demonstrated by an analysis of Pathstone's 490 full-time employees. At the current salary threshold of just about $23,000, Pathstone has to review the job duties of 176 employees to determine their exemption status. At the proposed threshold of $35,000, we have to review the job duties of 133 employees. And at the 2016 proposed threshold of about $47,000, we have to review the job duties of only 102 employees. It quickly becomes clear that as the salary threshold increases, the number of employees that must be continuously reviewed under the duties test decreases. There are numerous strategies that can be deployed once it's determined that an employee is subject to reclassification, none of which are specifically mandated by the law. For employees who routinely work no more than 30 hours per week, we can reclassify them with little to no financial impact. For employees who are close to the new salary threshold and who routinely work more than 40 hours per week, we can increase their salaries to maintain their exempt status, and we can mitigate the financial impact by reorganizing job duties and workloads. Reallocating job duties is particularly effective when job duties are moved from an employee who has been reclassified as non-exempt to an employee who is given an increase to maintain their exempt status, because we can directly tie the salary increase to additional job duties. Some critics claim that reclassification reduces scheduling flexibility and benefit eligibility. However, not all employers tie benefit packages to exemption status. At Pathstone, our president and CEO has the same benefit package as an entry-level receptionist. Furthermore, while non-exempt employees certainly do come with more time-keeping requirements, technology is making this task significantly easier. Nonprofits have been held up as a poster child for employers that will be hurt by an increased salary threshold. But this argument is invariably advanced by those who are not familiar with mission-based work. There is no question that a higher salary threshold will impact our operations, particularly considering that we are prohibited from renegotiating our federal contracts. However, just as our mission must guide our actions when we serve our constituents, it must also guide us when we act as an employer. Pathstone's mission of economic self-sufficiency compels us to support robust regulations and oppose the department's attempt to undermine strong overtime protections. Thank you.
Thank you very much. I'll now recognize Ms. McCutcheon for 5 minutes.
Madam Chair, members of the subcommittee, thank you for giving me the opportunity to speak today on the proposed overtime regulations. I have been living with these regulations for almost 20 years now, revising the regulations in 2004 when I served as the Wage and Hour Administrator, and preparing comments for the Chamber in 2015, 2017, and for the current proposal. For our conversation today, it is important to understand two things. First, in the FLSA, Congress created exemptions for executive, administrative, and professional employees based on job duties without reference to salary. The text of the statute refers only to job duties. Second, going back to 1940, again and again, the department has stated that the purpose of the salary level is only to screen out, obviously, non-exempt employees. If the salary level becomes too high, however, it stops serving as a proxy for the duties test. It becomes the whole test, which is what the Texas court found and his reason for invalidating the 2016 rule. The department proposes to increase the minimum salary level for exemption by nearly 50%, from less than $24,000 annually to over $35,000. Much of the commentary around the department's proposal has focused on the salary level, but more important than the final number is the method the department used to reach it. The department used more or less the same methodology as in 2004. A rule, by the way, that has been in effect for nearly 15 years without a single legal challenge. That methodology was the best choice for two reasons. First, it is consistent with historical practice in the department, and second, it is the approach that best finds that salary level that can serve as a proxy for job duties without replacing the job duties tests. Now, we must remember that the FLSA needs to work throughout the country without adverse impact on local economies and jobs. It must work in every state and every industry, in large cities and tiny towns, for small businesses and large, for profits and nonprofits. Like the minimum wage, the states can set a higher threshold salary level, and they have done so. In California, for example, exempt employees must be paid an annual salary of $49,920. The state of Washington is expected to soon set a similar salary level for exempt employees in that state. Then in New York, the salary level is $58,500. Now, while that high level may fit the economic conditions of New York, it does not work in Alabama, where it is less expensive to buy a house than it is to buy a parking spot in Manhattan. In any case, applying the 2004 methodology to set the salary level was the department's only viable option, given the Texas court's decision invalidating the 2016 rule. Referring to the statutory text, the court reasoned that Congress gave the department authority to define the exemptions by reference to an employee's duties, not by reference to their salaries. The salary test was therefore lawful only when it did serve as a proxy for duties. For most of its history, the department used the salary test in just that way. But in 2016, the court found the department exceeded its authority by setting out to reclassify millions of employees based on salary alone. The court also stated that if the department had simply updated the salary levels using the 2004 methodology, its action would almost certainly have been lawful. Most argue that it is time to increase the salary level. Those who oppose the proposed $35,000 salary level, that it is too low, want the department to stubbornly defend the 2016 rule, offering no compromise between $24,000 and $48,000 even today. But defending that rule will almost certainly result in extensive and lengthy additional litigation, as the Trump administration did appeal the grant of the injunction to the Fifth Circuit, and that appeal is still pending, and also perhaps a trip to the Supreme Court. Years of additional delay and with uncertain results. It was the overreach in 2016, the refusal to find compromise even today, which has undermined overtime protections for the last 3 years, not the current proposal. Thus, respectfully, I must take issue with the title of this hearing, as I disagree with the conclusion that the department is seeking to undermine the FLSA's overtime protections. The opposite is true. The department's proposal will ensure that the salary level is increased now. Thank you.
Thank you. Mr. Weinbrink, you are recognized for 5 minutes.
Thank you, Chairwoman Adams and Ranking Member Byrne. It's a great pleasure to be here before you all today. I'm a workers' rights lawyer from Pennsylvania, and I've had the great privilege of representing thousands of workers throughout this country in Fair Labor Standards Act cases, and hundreds of workers who've been paid salaries and have not gotten the benefit of overtime. I want to tell you today about my clients, about my salaried clients. And all of the people I'm going to tell you about today are individuals who make over $35,000 a year. Generally speaking, they make somewhere between 35 to the low 40s. These salaried clients who I represent, almost none of them went to college. Very few went to college. They generally work between 55 and 70 hours per week. It's very important that you all realize that in fast food and in the retail industries, it is not uncommon for workers to work, salaried workers to work 65, 70, sometimes even 75 hours a week. My clients are working class. Very few of them have any meaningful amount of savings. Very few of them have retirement accounts. Many of them lack reliable transportation. And I would say that the great majority of them are literally living paycheck to paycheck. And what do my salaried clients do? What do they do on a day-to-day basis? I'll tell you what they do. I've represented account managers. They get a fancy job title, account manager, paid a salary of about $36,000, $37,000 a year for a custodial service companies. These workers are basically doing janitorial work at nursing homes, cleaning the floors, washing windows, doing janitorial work. The store managers and assistant store managers who I represent at small convenience stores and at dollar stores and at other retail establishments, what are they doing on a day-to-day basis? They're working the cash register. They're stocking shelves. They're cleaning the bathrooms. They're cleaning the floors. If they work in a convenience store that's associated with a gas station, they're going outside and they're cleaning near the gas, where the gas is pumped. The salaried employees who I represent in the restaurant and fast food industry, they're given the fancy job title of assistant manager. But what are they really doing on a day-to-day basis? They're bussing tables. They're serving customers. They're expediting food. They're cooking. they're washing dishes. Over and over again. Over and over again. It's the same business model that I see in every one of these cases. And the business model is very simple. Take a location, whether it be a store, a restaurant, staff it with 1 or 2 salaried employees and a bunch of hourly employees. Set a very strict payroll budget that's very difficult to meet if you give the hourly employees overtime. Remember, if you give the hourly employees overtime, you have to pay them overtime. Every extra hour that an hourly employee has to work is an hour that the company has to pay for. But if you give all that extra work to the salaried employee, the employer doesn't have to pay anything. It's free labor. So the business model is very simple. Staff the location with a couple salaried employees, and whenever you need someone to do extra work, give that extra work to the salaried employee and benefit from that free work. This fight that I've been watching, and in some ways have been a part of, for the past 2 or 3 years over these regulations, what this is all about is preserving that business model. The reason the chamber is putting up the fight that it's fighting is they will fight very hard to preserve that business model. And I urge the members of this committee to do everything you can to take that business model away. Thanks so much, and that's all that I have.
Thank you very much, and I want to thank all the witnesses for their testimony. Under Committee Rule 8A, we will now question witnesses under the 5-minute rule. I now recognize myself for 5 minutes. Dr. Shearholtz, as I understand it, if the department's approach for setting the salary level is flawed, it will result in a salary level too low. And a salary level that is too low makes more employees likely to be improperly classified as exempt, depriving these workers of overtime pay. So can you speak to how the duties test and the salary level work together to draw a line between those workers who are eligible for overtime pay and those who are not under the white collar exemption?
Yes, thank you. So the salary threshold, and Tammy talked about this too, can just best be thought of as a really bright line proxy for the duties test. It makes it simple to determine exemption. It makes sure that workers who work who are, like, say, frontline supervisors, who work limited number of, they do a great deal of non-exempt work and have little bargaining power, that those workers are not taken advantage of, and helps reduce the misclassification of non-EAP workers as EAP exempt. So that's what the salary threshold does, and then the duties test is a more specific mechanism that helps determines exemption for people who pass the salary threshold. Those two tests have always worked together. Unlike what was claimed by the district court judge, the 2016 rule did not eclipse the duties test. It was still needed for 6.5, the determination of overtime status for 6.5 million workers above the duties test. So that's the way those two tests work together.
Okay, Dr. Shearholtz, the department has based its current proposal on the methodology used in 2004. The slide that we have before you, we have shows that the salary level set since 1949 inflated to $2020, so we can compare what the department is proposing to historical levels. I think the chart makes a few things clear. First, the 2014 salary level was not in line with the historical trends, and it tells me that there was something wrong with the methodology they used to that salary level. Secondly, the 2016 rule was in line with the historical trends. And third, the current administration is taking an approach that would once again take us outside of the historical levels. Why was the 2004 update to the salary level based on a flawed methodology?
I'm not sure of the motivation for that, but it absolutely was in error. There was an absolute pairing of a low salary threshold with a weak duties test. It shouldn't have happened, and that's what we have been stuck with until now. There's an opportunity to really fix that error.
Why would the department choose to double down on a flawed methodology from 2004 for its current proposal, and how does the department's approach affect working people?
To be honest, I think the department is bowing to the interests of the Chamber of Commerce. The core provisions of their proposal is actually almost exactly what the Chamber asked for. I think this department is really prioritizing the interests of corporate executives over those of working people and leaving working people behind.
Ms. McCutcheon states that the department had no choice but to use the 2004 methodology for its recent proposal. Is this true?
Nope, it's not true at all. The 2016 threshold the 2016 rule was vacated by a single district court judge in Texas. The department could have defended it.
Okay. Thanks very much. I'm going to now recognize the ranking member for his questioning, 5 minutes.
Thank you, Madam Chairman. Ms. McCutcheon, if I'm right, throughout the entire 8 years of the Clinton administration, we didn't get an increase in the threshold, but midway through the Bush administration, we did, under your leadership. And it was only at the very end of the Obama administration that we got a new rule, and that rule was so flawed it was struck down by a federal court. So I agree with you that the overtime salary threshold should be updated, and I applaud the Labor Department for proposing a solution in this area and for being responsible. My biggest worry is that setting the threshold too high, and I think you referred to this, will harm small businesses, nonprofits, and institutions of higher education, as well as the populations they serve. In your opinion, does the proposed rule adequately take these distinct employers into account?
I share your concern, and I would add to that local government entities who operate on budgets and objected to this 2016 rule, as did nonprofits, higher education. Except in 2016, the department also shared your concern and thus set the salary level at the low end of salaries paid to employees in lower wage regions, industries, small businesses, et cetera. In 2016, we saw a huge negative reaction and concerns from the vast majority of nonprofits who filed comments, local governments and higher education. I think most of the comments that have been submitted in response to this proposal support the $35,000 level, although that is not universal. And in meetings held by the Small Business Administration Office of Advocacy, we did hear from to small business that even at $35,000, the new salary level would be devastating to them.
Well, that doesn't sound like a bunch of big corporate executives.
No.
These bad, mean corporate executives. It sounds like people that run colleges and universities and nonprofits and small businesses, and as you say, municipalities. So we do have to take that into account, or the Department of Labor has to take that into account when they set this rule too. Don't they have to take that into account?
They certainly do, and that's why the Texas court invalidated it. And I do want to reemphasize that that is on appeal. The Trump administration appealed it. And, if it moves forward, because this proposal is pushed aside, we have years of litigation in front of us before we get any increase at all. And I think that would be devastating, too.
I agree with that. It seems to me that sometimes we'd rather litigate than actually solve a problem. And it sounds like what the Department of Labor doing is trying to solve a problem. And I've been listening to some of the testimony about a single district judge. That's our system. We've got single district judges that have ruled against President Trump all over the country, and it is in effect. That's the law. We all learned that in law school, that a single district judge can do that. But as you say, that ruling's on appeal, and I hope that while it's on appeal, that the Department of Labor will take responsible action to take care of the working people in America out there. Let me change subject for a minute. We know that one of the most extreme impacts of the radical salary threshold included in the discredited Obama overtime rule would have been a mass reclassification of employees from white-collar salaried employees to hourly workers. By the way, I heard from some of those people, and they didn't like being reclassified. What negative effects does this type of reclassification have on workplace advancement opportunities, worker status and morale, and workplace flexibility?
Well, Mr. Byrne, in response to the Department of Labor's 2017 request for information from the public about the impact of that high salary level, we did a survey of employers about how they reacted to it, particularly employers who implemented the change before the injunction was entered. And what they told us is that they've reduced hours, they reduced jobs, they automated, and they raised consumer prices. And how that is good for employees, I just can't understand.
I agree with you about that. Sometimes in some of this high-flown rhetoric, we forget about the real people that are out there. And I'm telling you, I heard from a lot of people who said they did not like being reclassified. They took it very negatively themselves. And I just want to applaud you, and when you had the responsibility, for being responsible, for proposing a responsible rule based on responsible methodology. And I just wish that the previous Democratic administration and the subsequent Democratic administration would have done the same thing, because if they had, the workers of America would have been a lot better off. And with that, I yield back.
Thank you very much. We'll yield now to Mr. Takano from California for 5 minutes.
Thank you, Chairwoman Adams, for this critical hearing on overtime standards established under the Fair Labor Standards Act. Yesterday, I reintroduced the Restoring Overtime Pay Act, a bill that would strengthen worker protections by raising the overtime salary threshold under which most full-time salaried workers are automatically eligible for overtime pay. It sets the salary threshold to the 40th percentile of earning of workers in the lowest wage census region. In 2020, the salary level would be about $51,000 per year under my bill. In 2016, the Obama administration finalized a rule that would have strengthened overtime for workers by setting the salary threshold to $47,476, with automatic updates every 3 years to remain in line with the economy. Madam Chair, I have a signed letter by dozens of nonprofit organizations that have commented in support of the 2016 final rule. I have asked that this letter be entered into the record.
Without objection.
Yeah, without objection. In March, the Trump administration proposed a new rule to set the salary threshold at $35,308 a year in 2020 without automatic indexing. This administration proposal is troubling as it does not go far enough to strengthen overtime protections for workers and would leave behind about 8.2 million workers, far from being a radical proposal. The Obama administration proposed what was adequate. The Trump administration falls far short of serving ordinary Americans. Madam Chair, I have a report from the Economic Policy Institute that outlines how fewer workers will benefit from the Trump proposal compared to the Obama rule. And I ask that this report be entered into the record.
Without objection.
My first question is for Dr. Schierholz. As was mentioned, a Texas district court concluded that the 2016 salary threshold was too high because the number of newly overtime eligible workers was high. Can you respond to this flawed reasoning, Dr. Schierholz?
Yeah, that's a really good point. So the number of workers affected by any increase in the salary threshold is an absurd measure to use to determine whether that threshold is appropriate or not, because the number of workers affected by any threshold is that measure is affected by things that have nothing to do with the appropriateness of the threshold, like how long it has been since the last update and whether the prior update was appropriate. The reason the 2016 rule had affected a lot of workers was because the rule had not been appropriately updated for over 40 years. That is the reason why.
It atrophied. The law that was meant to protect workers abuses. I mean, the reason why they put this threshold in and protect salaried workers is because employers found clever ways to get around the overtime rule for hourly workers. And I find it a very specious argument that because we had neglected at the federal government to set a new threshold level, suddenly a rule which would have caught them up, ordinary workers up, The judge then said, oh, there's too many people that would be eligible. It really angers me that such specious arguments are being used in this committee room to leave these workers vulnerable. Because the Trump administration's refusal to defend the salary level in the 2016 final rule, American workers are losing wages every day. In 2020, workers stand to lose about $1.2 billion in wages. Dr. Sherholtz, my bill is based on provisions from the 2016 Obama-era rule. How would the restoring the overtime pay strengthen overtime protections for workers?
It would get, for workers who would get new protection, there'd be 4.6 million workers who would get new protections under the Restoring Overtime Pay Act, or would get a bump up to the new salary, and there would be 8.9 million workers who earn between the old salary and the salary in this act who would get strengthened protection.
I want to get one more question. Mr. Weinbrake, it really angered me, the model you illustrated. Does the Department of Labor have the authority to include automatic increase provisions in its rulemaking?
Sure. Remember, in Section 13B of the...
Turn your microphone on, please.
Sorry about that. In Section 13B of the Fair Labor Standards Act, Congress explicitly gave the Department of Labor the authority to, quote, define and delimit the white collar exemption. And under that authority, that's an extremely broad grant of authority. The Department of Labor can implement a salary threshold, could determine what that threshold should be, and can index. There's nothing, no reason why it can't.
Thank you. Madam Chair, my time has run out, but before I yield back, let me just say that this court ruling, I don't know that it would have taken years and years for this litigation to go through. Such a laughable ruling. Any appeals court would have to look at what the law explicitly says in statute. Where they had the authority, there was no overreach here. And the current overtime threshold of overtime pay is out of date and does not support working
Gentleman's out of
families. I
time.
yield back.
Thank you. I'll recognize Dr. Fox for 5 minutes. Dr. Fox?
Thank you, Dr. Adams. Ms. McCutcheon, as you indicated, salaries vary from region to region and industry to industry, and the cost of living varies across the country. Despite this reality, your testimony indicates that the discredited Obama DOL's overtime rule implemented a salary threshold at the 40th percentile of all full-time salaried workers nationwide, while in the past, DOL used the 10th and 20th percentile of salaries in the lowest wage regions and the industry sector with the lowest wages to determine the proposed threshold. Which approach is more appropriate given the alarmingly negative impact the Obama rule would have had on small businesses? Is the current proposed salary threshold fair to small businesses and employees alike?
Well, I was at DOL when we set the threshold I was at DOL in 2004 when we chose the 20th percentile, so it probably will not surprise you that I think that that is the most appropriate level. Now, we doubled the 10 percentile that was used in 1958 because of the changes that we made in the duties test in 2004, just accounting for all that mismatch argument that we keep hearing about. In 2016, and nobody explained why that 20 percentile was not appropriate or was insufficient to avoid that mismatch, or why doubling to the 40th percentile in 2016 was necessary or necessary at all since we'd already adjusted. Now, since 1940, DOL stated that the only purpose of the salary level is to screen out those obviously non-exempt employees. No one has presented any evidence at all that employees paid below the 40th percentile are obviously non-exempt, all of them, so that it's a reasonable proxy. So it may be true in San Francisco, but it's certainly not true in rural communities in your own district that everybody below the 40th percentile is obviously non-exempt. I think the 20th percentile is the appropriate line to protect employees adequately in all states, in all regions, in all industries.
Thank you. Ms. McCutcheon, the invalidated Obama Labor Department's overtime rule included a provision that indexed the salary threshold for exempt workers, which would likely have increased the threshold every 3 years without fulfilling all the procedural requirements designed to produce sound rules. How would this discredited approach have impacted business owners and in particular small businesses? And does the current DOL overtime proposal balance the need for timely updates to the salary threshold with the need for public input regarding potential impacts on stakeholders, including small businesses?
Well, the automatic increasing, which by the way doesn't occur anywhere else in the FLSA, would have really adversely impacted small business and local governments and universities, because you would have changes that occurred automatically regardless of the economic conditions, right? And so the small businesses would be given increases even if economic conditions didn't justify it, as our numbers, as you know, always are not fully up to date. They follow our major economic indicators, and so it would be very precedential for that. I think DOL has struck a good balance, committing to review the salary levels every 4 years, but not make increases until it goes through the notice and comment rulemaking required by the Administrative Procedures Act, and that is what the FLSA text requires. So we said in 2004 rulemaking that Congress did not grant DOL the authority to make those automatic increases, and that has not changed. Congress has not passed an automatic inflationary increases to the minimum wage, as we have seen states do. So if the minimum wage is not indexed based on inflation, how can anybody argue that it's appropriate to index by inflation an exemption from the minimum wage? I just don't think how that argument can possibly be true.
Well, thank you for that. You basically answered my third question, but I'll make one quick comment. What you indicate is we could be in the midst of a recession and that automatic increase be written into the statute and have to go into effect even if we were in the midst of a recession, right? But let me say, you've mentioned this. I don't know if you want to say anything else about your feeling that the department does not have the authority by statute. Is there anything else you'd like to add to that?
I would like to add to that, speaking on my own behalf, because this is not the view of the chamber, and I'm probably an outlier. I do not believe the Department of Labor has the authority to set any minimum salary level for 3 reasons. First, the text of the statute does not include compensation at all. It's just duties. Second, other exemptions in the FLSA do include compensation requirements, like the Section 7I exemption for commissioned employees, like the hourly rate for exempt computer employees. So when Congress wanted to put in a compensation requirement, they knew how to do that. And third, remember, these white-collar exemptions are exemptions from both the minimum wage and overtime. And I personally just don't see how Congress could have authorized the Department of Labor to set a minimum wage for an exemption from minimum wage, which is higher than minimum wage.
Thank you, Madam Chairman. Thank you for your indulgence.
Thank you very much. I'll recognize now the gentlelady from Pennsylvania, Ms. Wild.
Thank you, Madam Chairman. Before I start, I'd ask recognition and unanimous consent to introduce into the record a letter from the Pennsylvania Department of Labor and Industry. It's a letter supportive of an increase in the overtime exemption salary threshold for executive, administrative, professional, computer, and outside sales.
Without objection.
Thank you. Ms. McCutcheon, you've made it perfectly clear that you are opposed to automatic indexing. You are aware, are you not, that the Secretary of Labor, Mr. Acosta, publicly stated that the Department of Labor should consider automatic indexing to make updates more efficient than the time and resources-intensive rulemaking process?
Yes, I'm aware of that.
And so you disagree with him about that?
Yes.
Would you agree that automatic indexing would be more efficient on a time and resource basis than engaging in formal rulemaking? And I'm just asking you whether you believe it to be more efficient on a time and resource basis, not whether you agree with it.
I do not know. I mean, it's certainly against the law.
It's certainly, I'm sorry?
It's against the Administrative Procedures Act, right? So the Administrative Procedures Act was enacted to make regulations hard. So the fact that it's hard to regulate is not a sufficient reason to ignore the requirements of the Administrative Procedures Act.
Well, you're not disagreeing that including automatic indexing would be a legal aspect, would you?
If Congress changes the statute to allow automatic
That could be done.
indexing, then it would be fine.
And that would be in accordance with the Secretary of Labor's recommendations, right?
I don't know if that's his most recent view. He did say that about 2 years ago in a Chamber of Commerce speech, which of course tells you he doesn't do everything the Chamber of Commerce wants.
And in February of 2019, you were quoted in a Bloomberg article as saying that if the Department of Labor tries, and that was just in February of this year, tries to automatically index that, quote, "we will bring suit in Texas again," end quote. Is that a correct statement of your quote?
That's, as far as I remember, yes.
Am I not correct that automatic updates would grant employers a degree of certainty and predictability, at least more so than whether proposed rules might be finalized?
It's tough. Predictability is tough because the method that the Department of Labor used in 2006 to set that salary level is not easily repeatable. In fact, Rodden Bird, the economist for the Chamber and a former DOL chief economist himself, had trouble duplicating and replicating the analysis that got to the Department of Labor to its current proposal. It took him months to do so. So I doubt it would provide any predictability for a small business who is not a PhD economist.
Certainly more predictable than a formal rulemaking process, is it not?
With a
You don't
formal-
need to answer that. Let me switch over to Dr. Shearholz, I believe. You've heard this line of questioning. Can you tell us why your written testimony indicates that automatic indexing is crucial?
Yeah, and I'll just make one correction. The 2016 rule, that was based on a series that was published on a quarterly basis by the Bureau of Labor Statistics. Anyone could look at that at any time and know exactly what to expect going forward. And the automatic indexing is absolutely crucial because when something isn't indexed, that means that the threshold immediately erodes over time as a standard, and it provides fewer and fewer and fewer protections.
Exactly as we've seen happen, correct?
Yep, that's exactly right.
Let me switch to Mr. Weinbrink. It's good to see you. Your testimony talks about employers who misclassify employees as management to fit that EAP exemption, and I know you've litigated a lot of these cases. You give a number of examples of fast food people being classified as assistant managers when in reality all they're doing is working cash registers and making burgers. Could you tell us, please, what, if any, impact would enactment of the Obama-era salary level have on the number of lawsuits that allege employer misclassification?
It would have a huge impact. I've estimated, when I've looked at my law firm's inventory of white-collar misclassification cases, that if the salary threshold was $47,000 a year, we probably would have filed 70% less lawsuits over the course of the last 5 years.
Thank you very much. I yield back.
Thank you. We'll yield now to the gentleman from North Carolina, Mr. Walker, 5 minutes.
Thank you, Madam Chair, and thank you to our panel for being here today. Our friends and colleagues claim that the Department of Labor proposed overtime rule hurts workers the most, when in reality, the Obama administration's Department of Labor overtime rule would have resulted in millions of employees who perform exempt duties being reclassified from salaried to hourly workers. Ms. McCutcheon, I believe this negatively impacts their opportunities for career advancement, which poses detrimental effects on our local businesses and workers. Can you expand on some of the negative impacts on the 2016 Obama overtime rule that would have on small business workers? And we're not talking abstract here. We're talking about the reality of it. Would you address that, please?
Certainly, and thank you for asking me that question. Employees who have been exempt view being reclassified as non-exempt as a demotion. And you're non-exempt, you have to track your time. These employees hate having to punch a time clock. When you're an exempt employee, you can leave work early on Friday. You can take time off to go to your children's sporting event, and you do not get docked any pay. Employees who are reclassified, in particular, in addition to the opportunities, they do not like having their time closely watched and monitored and losing pay when they decide to take a half day off.
Sure, and a lot of that is just a relationship on a good employee that earns some of those privileges because of the amount of work and some of the things they're getting accomplished, and it really does put them in a negative situation. The rules around overtime pay are also complex. Many American small businesses, such as franchises, do not have the extensive legal teams and accounting departments to help navigate through these laws. Very complicated. Yet many franchisors and other prime companies are ready to provide guidance to their franchisees and business partners to help them implement the department's new rule requirements. But concerns over triggering joint employer liability, as you know, causes hesitation to provide such guidance. With over 24,000 franchisees just in my home state of North Carolina, this kind of guidance would have a significant impact. So, would it be beneficial, Ms. McCutcheon, for the Department of Labor's proposed rule to include a safe harbor provision similar to the language included in the department's associated health plan rule to ensure employers are protected from unnecessary joint employer liability when promoting overtime pay in the workplace? Long question, but would you speak to that?
I think it would be incredibly beneficial, and I don't see any downside or any barrier to the Department of Labor for doing so. As you know, most franchisees are small businesses. They do not have lawyers. They do not have HR staff. So they need to get to guidance. They need to learn and educate themselves about the FLSA in some way in order to comply. And the Department of Labor and the Small Business Administration, they just don't have enough resources to do that. Now, the Department of Labor has done great this year in enforcement. They collected a record number of back wages this year, $305 million, $33 million than in 2017 with fewer investigators. But enforcement is not enough. You will never have enough investigators to go into every business, particularly small businesses. So the only way to improve compliance and to help these franchisees is to comply is an idea like yours.
Just the facts, Ms. McCutcheon. The DOL's methodology in calculating the updated salary threshold is based off the 2004 method used when you were serving as administrator of the Wage and Hours Division. Can you please explain how the 2004 methodology avoided the damaging consequences of the 2016 rule and would still do so today?
Well, it's the difference in the percentile, right? The 20th percentile and the 40th, which basically doubles the salary level threshold, and that's what happened in 2016. But it's also the data that they use. We looked at lower wage industries and lower wage regions, the methodology in 2006, and frankly, the methodology proposed in this proposal includes, for example, salary data from Virginia, Maryland, and the District of Columbia, which are 3 of the 10 highest wage areas in the country. So you got to look at the data too.
Sure. Well, we thank you for being a witness. We thank you for your expertise in this area. With that, I yield back, Madam Chair.
Thank you. I'll yield now to the gentlelady from Michigan, Ms. Stevens.
Thank you, Madam Chair. I would like to submit by unanimous consent 2 letters for the record. One from the governor of my state of Michigan, Governor Gretchen Whitmer, and the other from the AARP. These comments were submitted to the Wage and Hour Division at the Department of Labor regarding the department's proposal to narrow the scope of workers eligible for overtime protections.
Without objection.
Thank you all for joining for today's hearing, and thank you to our remarkable chair for holding this hearing on the restoring the value of work, evaluating the Department of Labor's efforts to undermine strong overtime protections. This is an important part of our committee's work as we evaluate what the American worker is experiencing, as we've proposed and sought to put through our committee legislation that will raise the minimum wage, and as we engage in this conversation around what it actually means to put in a full day's work and seek to get ahead. And it's a point of irony as we often have grand conversations within this body around regulation regulatory burdens, and yet we're looking to unleash or remove some of those burdens for our workers and help them get ahead as we tackle this topic. But my questions are going to start with Dr. Shearholtz. Strong workforce protections and overtime protections in particular are critical to older Americans in the workforce, with older adults continuing to get pushed out of the workplace, 56% to be exact, before they decide to retire. It's more important than ever that our laws protect and incentivize living wages for older adults, especially in the midst of a retirement savings crisis. So, Dr. Shearholtz, what are some segments of the workforce that are most impacted by weak overtime protections?
So one of the things I can do is look at the workers who would be left behind by the current proposal relative to the workers that would have gotten protections under the 2016 rule. And I have some things in front of me, but 1.7 million workers over the age of 55 would be left behind by the current proposal relative to the 2016 rule. So you're right, we see a lot of workers, older workers affected, along with women, along with people of color, along with parents. It really hits the broad middle class.
And additionally, weak overtime protections for all Americans greatly impacts how much time and resources family caregivers are able to allocate to their loved ones, especially as workers with lower salaries are in many cases required to work many extra hours without any pay at all. And I was wondering, Mr. Winbrake, in your experience representing workers, how does a low salary level test and thus weak overtime protections impact employees' work-life balances?
Sure. Well, as I said in my testimony, there's this business incentive to shift all of the work onto the salaried employee because the company doesn't have to pay anything extra for that extra work. I have represented many clients who have worked on a regular basis, 60, 65, 70 hours a week. I've also, many of my clients have been referred to me by workers' compensation lawyers. And the reason for that is because when you're working 65, 70 hours a week, hauling inventory at a dollar store, or on your feet all day in a kitchen, you get hurt. You get hurt at work. And so even though these individuals are called executives for purposes of the law, they're not executives. They're blue-collar workers, and they're getting hurt. This is also taking time away from their families, and they very much resent that they're working extra hours for free and not being able to be home with their kids or their spouse.
Yeah, thank you. And with the remaining time I have, Ms. Babak, I wanted to recognize you for your leadership, being an HR representative and testifying here today, particularly given the work that you do, the paperwork that you have to do, the regulations that you need to comply with. And if there's any other points here, particularly along the lines of on that paperwork front that you could shed light on from your experience, we'd love to hear from you.
Absolutely, thank you. One of the things that comes with the automatic updates, employers do like regulatory predictability and stability. And so when we have these drastic and sporadic changes in the threshold that, range in these dollar amounts and these increments of time, it's very hard for us to implement and kind of play catch up. So we actually do prefer regulatory predictability. And as far as paperwork, that's certainly what we seem to be making a living of in the HR world, but we really do want to reduce it. And one of the things about that salary...
Young lady's out of time.
All right, thank you. I yield back.
All right, thank you. I'll recognize the gentleman from Virginia, Mr. Klein.
Thank you, Madam Chair. Thank you for holding this hearing. It's amazing to me that we are holding a hearing that considers going backward when the economy is doing so well. We should be focused on reducing regulations so that businesses have more flexibility to provide the best options to their employees. The Department of Labor has rolled back more regulations than any other federal agency in the last 2 years, and I commend them for that. And there are tangible results that all of our constituents are benefiting from, no matter where you are. The economy is booming. We have the lowest unemployment rate in 49 years, 3.6% jobless rate, including part-time, is the lowest in 19 years. GDP, the last 2 quarters, 2.2 and 3.1% in the first quarter. 238,000 new jobs created at the start of the year, 151,000 in the past 3 months, but only 75,000 new jobs created in May. There is a danger. There's a real danger of this economy slowing, and to even consider additional regulations that would take this economy in the wrong direction are quite frankly, it's very distressing that we're even talking about them. So I'll ask Ms. McCutcheon, many workers place a high value on workplace flexibility, which allows them to maintain certain aspects of their personal life that are important to them. This economy is definitely focused on workers having choices because unemployment is so low. So how would this Obama Department of Labor overtime rule, which we are lucky that it did not go into effect because, quite frankly, it would have started us behind the 8 ball before this economic recovery even began, and the current boom would have been slowed by so much more. How would this rule have undermined the flexibility that so many workers value, and can you elaborate on the differences between salaried workers and hourly workers when it comes to workplace flexibility?
Right. Let me take your last question first. An exempt employee has a guaranteed salary. That means regardless of the hours they work, whether under 40 or over 40 or even an hour, they get their full salary in any week in which they perform any work. A non-exempt employee is paid for the hours they actually work. And that really comes into play with flexibility. It means that if you are reclassified as non-exempt, your hours are going to be closely watched, because although we can force an increase to the minimum salary level, we can't force employers to provide overtime hours. And so the hours that they work are forced to be under 40 because of the cost. I think that's even in Ms. Babcock-Steiner's testimony. That's one of the options. And a lot of employees prefer to work more. They prefer to work different times, especially millennials. So less opportunity for putting in the extra hours in order to advance up the chain in a corporation, more control of the hours you work and when you work, because your employer needs to know when you're working. So there goes all the teleworking opportunities for especially millennials who prefer to work at home and don't want the 9-to-5 job.
And with all the disruption that this rule caused, or was in the process of causing by more than doubling the salary threshold, can you speak to the impact that it had on small businesses? You spoke to it earlier, but small businesses are a major part of my district, just about everybody's district, but in particular in this gig economy that we have, and you spoke to that. Small businesses are being created and changing and shifting at even faster rates.
Well, the extra money for the overtime pay just doesn't come down from the air. My mom used to tell me money doesn't grow on trees, right? For a small business, they have to find that extra money that the government is requiring to pay from somewhere. It has to come from increased consumer prices. It has to come from reduced number of jobs or hours. And in this day where we're all concerned about the impact of artificial intelligence, it can often come from automating jobs completely when the price of the cost of providing that labor and that overtime exceeds the cost of actually automating.
Thank you. And Madam Chair, I yield back the balance of my time.
Thank you. I'll recognize the gentlelady from Minnesota, Ms. Soma.
Thank you, Chairwoman. I would like to ask unanimous consent to submit for the record a letter from the AFL-CIO, which emphasizes the need for strong overtime regulations.
Without objection.
Dr. Shearholt, in your testimony, you describe overtime protection as an essential part of ensuring a thriving middle class. I couldn't agree more with that assessment. If an employer expects their workers to put in time beyond the standard 40-hour work week, then that work should be compensated. If workers are going the extra mile, why shouldn't employers be expected to do the same? But after seeing the latest overtime proposal, I'm afraid this protection is being eroded just like so many others have been in the past few years. I'm concerned that the current administration's only goal is to make sure that we have an economy that only benefits the wealth. With that in mind, Dr. Schierholz, can you tell us how many workers would be left behind by the Trump administration's proposal?
Yep, I calculated this using the exact methodology that DOL uses and found that the workers who would have gotten protections under the 2016 rule but will not get protections under the Trump proposal if it's implemented number at 8.2 million workers.
And which workers would be hurt the most?
It's a real cross-section of the middle class, but I find that, I have these numbers, 4.2 million will be women, 3 million people of color, 2.7 million parents of children under the age of 18. It really will hit the middle class very hard.
And this isn't just a problem for today's workers. This proposal will have a long-term impact. By not providing automatic adjust in the future, the Department of Labor would likely be shortchanging workers for many years to come. Dr. Schultz, could you share more details about how working people would be hurt when the salary threshold remains unchanged for a long period of time?
Yep, again, using the exact same methodology for calculating the impact that DOL used, I found that workers, if the 2019 proposal is implemented, workers will get $1.2 billion less than they would have under the 2016 rule, and due to the lack of automatic updating in the proposal, that will grow to $1.6 billion over the first 10 years of implementation.
And these are this is real money in their paychecks. This will affect their ability to buy groceries, to be able to pay their bills, rent, possibly move to a new district with better schools. But as we've heard today, a lot of these workers would be denied that extra income under the current proposal. Could you please tell us how this proposal will cost workers in terms of lost earnings compared to the 2016 final rule?
Yep, so workers will get $1.2 billion less, and I think another thing is they will work more for that less money, because we know that when we implement overtime protections, the people will work less hours for free. So it hits both on you get less money and you work more. So it really is a hit to middle class workers.
So essentially, we are asking people to work for less money, and society will eventually supplement these people because their children will probably need food, so they'll go on SNAP programs. They'll probably need housing assistance, and we'll try to supplement that. They'll probably need to go to college, and we'll supplement that. And so by not making sure that they are being compensated for the work and that we're not paying a livable wage, we will ultimately be costing all of us more money.
Couldn't agree more.
Thank you so much. I yield back.
The gentlelady from Georgia, Ms. McBath, is recognized for 5 minutes.
Thank you, Madam Chair. I want to thank each and every one of you for your testimony today. Thank you for bearing with us. And I know that this question, or this has been discussed moments earlier. However, I'd like to get a different perspective. So, Ms. Babcock-Steiner, I'll probably be asking you most of the questions. I'd like to know from your perspective, how does the failure to regularly update the salary level impact employees? And are automatic updates beneficial for employers?
So from an employer perspective, again, we do like regulatory predictability and to know what is coming and when it is coming. In the past, there have been large periods of time between the updates to the salary threshold, and then the updates themselves have been widely varied as well. So from an employer perspective, it does make our life a little bit easier to know what is coming as far as the automatic updates.
Okay, thank you. Also to Ms. Babcock-Steiner, how can nonprofits, institutes of higher education, and other employers with budget constraints respond to increases in salary thresholds?
So, first of all, we have heard a lot about nonprofits today and people saying that, they'll be amongst the biggest victims here. And the reality is we do operate under our mission, so we think a little bit bigger than just one single bottom line. And so the other thing to keep in mind is the pressures that are put on nonprofits. The solution here is not to take away worker protections. The solution is to increase the funding for nonprofits. And so, short of that, which doesn't seem to be happening, we do have a lot of options for shifting around job duties. Shifting around job duties does not necessarily mean that the people who are exempt are going to be working significantly more hours. Shifting around job duties, it gives us an opportunity to maybe give somebody a pay increase to maintain their exemption status, and they have some additional job duties now that go with it. From an HR perspective, we don't like increasing salaries for the sole purpose of, regulation basically, but when we can tie it to a small increase in job duties, it becomes a very effective tool from our perspective.
Thank you. And one more question. When a salary level is too low, what practical effect does it have on the ability of employers to determine whether their workers are not eligible for overtime under the EAP exemptions?
So the salary threshold, anybody who's below that is automatically basically disqualified for the exempt status. And it's the number of people who are above the salary threshold that are really relevant from an HR perspective, because those are the people who I now have to examine each and every one of their job duties to figure out whether they're exempt or not. So when the threshold is so low, it becomes, basically worthless as a tool to make those non-exempt determinations. And so now we have constantly shifting job duties. Every time job duties change, every time direct reports change, even if a manager is not performing well, you actually have to re-examine their exemption status to see if they still qualify for it. So the lower the threshold, the more numbers there are people above it, which means I have to do a lot more work on the duties test.
Thank you so much. I reserve the balance of my time to my colleague, Ms. Jayapal from Washington.
Yes, Ms. Jayapal is recognized.
Thank you so much for yielding, Congresswoman McBath. I do have a full statement for my 5 minutes, but I have one question that I wanted to follow up on. Dr. Scherholz, Ms. McCutcheon stated that the 2004 DOL doubled the percentile from 10 to 20% to respond to change in the test. Is this the full story?
No, in fact, in that rule, they're very clear that change from the 10th to 20th percentile was actually accounting for other changes in the data set that was used. There were technical changes in the data set. So that increase in the threshold accounted for that. It did not account for the change in the duties test. In fact, there's many places in there where they actually talk about how this is a test that's consistent with the weaker duties test.
Thank you. I thought that was important to clarify, Madam Chair.
Thank you. Ms. Jayapal, you're recognized for 5 minutes.
Great, thank you. Thank you all to our witnesses for being here today. Your time is really precious, and actually that's what this hearing is about, whether we think people's time is precious, whether this administration thinks that the time of middle-class people who work for a salary is precious enough to be protected. So I appreciate you choosing to spend your time with us. I want to share 2 stories with you from constituents in my district. Heather, who was a kitchen manager, says, I worked 60 to 90 hours every single week. They wanted me there at 10 a.m. every day for receiving and ordering, and through our busiest kitchen hours, which lasted right up until closing at 1 a.m. After 9 months at that job, my body completely rebelled, and I had a full-on nervous breakdown. Here's Annie's story, who works in retail. I am often asked to stay later than my scheduled shift time. Regardless of my state of health or my scheduled shift, I am told that I need to stay until the job is done, even if that means sleeping at the store. These are two of the 8.2 million workers who would have had their precious time protected by the Obama administration's carefully tailored overtime protections. Of those workers who would have gotten protections, 2.7 million are parents of children under 18. Anyone who's a parent can understand, and I am one myself, anyone who's a parent can understand how important and precious your time is and how important it is to protect and value that time. Today, we know that the Trump DOL has refused to vigorously defend carefully reasoned overtime protections in court, instead coming up with this weak new overtime salary threshold with no inflation adjustments that would leave many workers behind. And I'm proud to say that, by contrast, my home state of Washington has just proposed very thoughtful salary overtime protections. Under these state protections, by 2026, salaried workers won't be left out of overtime protections unless they earn 2.5 times the state minimum wage. As my Governor Inslee, put it, we know a strong economy goes hand in hand with a strong and well-supported workforce. My state knows that people's time is precious and that they should be compensated fairly when they work so hard. And I don't understand why the Trump Department of Labor doesn't understand that. Dr. Sherholz, you were the chief economist for the Department of Labor under President Obama. You contributed to the worker protections that the Trump DOL failed to defend. Under those protections, workers would have had to earn a higher salary of $47,476 before they could be considered to be even possibly exempt from overtime pay. And that salary level would be updated automatically every 3 years. Why is it important to you, as the chief economist of the Department of Labor, to ensure that there would be those automatic adjustments?
When you don't have an automatic adjustment, the standard just immediately starts eroding the second it goes into effect, and as time passes, you get more and more, it erodes more and more. And if you look, between 1938 and 2004, the threshold was updated on average every 11 years. Like, that's the kind of, those are the kind of gaps that are going past over and over again, where workers are just left behind.
And the Trump administration's proposal fails to include automatic updates, but it instead includes this weak sort of statement of intention to propose updates every 4 years. What would be the impact of that failure, the administration's failure to include automatic increases in that final rule?
Yeah, an unenforceable sort of vague commitment to notice and comment rulemaking every 4 years is just a tried and true recipe for huge stretches to go by without any updates.
So workers would just continue to be hurt. And even if the Department of Labor does adhere to its commitment, would it be enough to protect workers in the future?
Even, if in the very unlikely event they were able to do notice and comment
always want to give
rulemaking
the
every
benefit
4
of the
years?
doubt,
Okay.
yeah.
Okay, so in that event, I still think that's too long. Like the Obama threshold, by doing it every 3 years, that pushed the boundaries of what is okay to let that erode over time. And I mean, I wished it were a year. We did it every year. So going 4 years is just, it's pushing it too far.
And Mr. Weinbrake, Secretary Acosta publicly stated that the department should consider automatic indexing, but Ms. McCutcheon made it clear that management lawyers would sue the administration if indexing or cost of living adjustments were included. Do you think that the Trump Department of Labor bowed to the threats of labor management side lawyers and lobbyists when it failed to include that automatic increase mechanism in its proposal?
Well, I don't know what the motivation was behind the administration's conduct, but I will say that at the Fifth Circuit Court of Appeals, in the appeal to the district court's decision, the Department of Labor totally changed its litigation position. In the opening appellate brief, it said that indexing was legal, and then in the reply brief filed by the Trump administration, it dropped that argument. It's very troubling as a lawyer, and I think we should all be troubled, those of us who just care about the government as an institution, when in the middle of a litigation, a governmental agency literally switches its litigation position in the middle of a case. So I don't know the motivation behind that switch, but I know that as a lawyer, I'm troubled by the kind of instability that's created when we can't rely on our government to take a consistent litigation position and carry it through. That is what's troubling to me.
Thank you. Thank you for that. And Madam Chair, before I yield back, could I have unanimous consent to introduce into the record Governor Inslee's comment letter on the 2019 NPRM and also a Bloomberg News article that quotes Ms. McCutcheon to the effect of management lawyers suing the administration?
Without
Thank you.
objection. Thank you. I want to recognize the Chair of the Education and, oh, I'm sorry, Mr. DeSanya. Oh, Mr. DeSanya, you're recognized for 5 minutes. I apologize to the Chair.
That's quite all right. I would have taken second place to the Chair. Well, I want to thank you all for being here. I also wanted to ask unanimous consent to submit for the record a letter from State Attorney Generals opposing the Trump administration's.
Without objections.
Mr. Sherholtz, I wanted to ask you sort of a disposable income, economic growth, regional question. And I do this in the context of having been in the restaurant business for 35 years in California, where we go beyond the federal laws, but we had a real problem with the underground economy. And we actually worked jointly when I was in the legislature, Republicans and Democrats, because the chamber was concerned that people who weren't complying and weren't paying our rules were undermining conscientious, law-abiding businesses and the relationship to the growth in the economy. Now, I know every state, every region is different, but I would argue our GDP, particularly in the Bay Area, has grown because we do have good protections for workers. And as somebody in the restaurant business, I couldn't afford to pay people anything, but it was my job to manage overtime, which created more jobs because, and you also wanted people in an area where there's high cost of living, but difficult transportation issues in the service industry to get people there, be able to get a livable wage so they can afford to actually live in the region. And this is the context of these urban regions are driving the national economy. 65%, 64% of GDP comes from these urban regions. I don't think that's right. I think we should be dispersing more jobs around the country. I have some people in the Bay Area who disagree with me when I say Google should take more of the jobs somewhere else. But the dynamics of a regional economy, having people in the service industry, for instance, have enough disposable income, because when we raised the minimum wage in California, I would argue, as the only member of the legislature who was also a member of the California Restaurant Association, that as long as it was proportionate, it was good for me because there was more disposable income. So could you talk to that a little bit from an economic standpoint, knowing that you can't pay everybody everything they want, but we're going in the opposite direction. And I would say this in context of it's a great economy if you're not relying on wages. When you rely on wages, you're falling further behind. When you look at the metrics on capital investments, if you own a house, if you own investments, it's a great economy. But this is what's adding to our inequality. So maybe you could just give a little summary of my comments.
Yep, no, I think that's really important. So we know we've had 4+ decades of rising inequality, stagnant wages for working people, and one key driver of that is the erosion of labor standards like the overtime protections we're talking about today. If we strengthen those protections, we reduce inequality, and what that does is it gets money into the hands of people who are likely to spend it, rather than people who have a low marginal propensity to consume, is the term that economists have, but people who have no choice but to spend the money, they get it into their local economy, that generates more demand for goods and services, that generates jobs, that's good for everyone. So in this way, these kinds of protections are deeply important, not just to the individuals who are protected, but to the economy as a whole.
And when you look at the regional disparities between urban and rural America, this reinforces the disparities. Correct?
Yes, yep, that's exactly right.
Mr. Weinberg, I want to ask you a question about litigation, unnecessary litigation, and our ranking member has some good points on this. But I read a book by Francis Fukuyama, and I actually agreed with him called trust. And his whole argument is he looks at the amount of infrastructure to get people to do the right thing, particularly in the business community. And he measures the United States and Japan and Europe over time, and I think we went from 5% in the 50s to 25%. One of his arguments is, I take from it, is that proper regulation is a better enforcer of ethical behavior than private rights of action. You sort of said this, that your business actually went down when the regulation was more focused. Could you maybe elaborate on that observation?
Sure. So what the salary threshold does is it creates a bright line test. Either, if let's say the salary threshold were $47,000, that's a bright line test. Most of the litigation in white collar misclassification cases happens with employees underneath the $47,000 threshold. In fact, when I look at my inventory, it's people between $35,000 and $47,000. So if for all those workers who right now it's iffy whether they're misclassified, we have to look to their duties. If instead we just had the bright line test, all of those employees underneath $47,000 would get reclassified without us having to analyze the duties test. And therefore, all of that litigation where lawyers fight about is the person's job duties executive or not, all of that goes away, and that's the basis for all of the cases that we file are happening in that gap between the Trump administration proposal and the Obama administration proposal.
I appreciate that. Another incentive for us to do what the Obama administration did, less work for lawyers, and I yield back.
Yes. I mean, I don't want to put myself out of business, but.
Gentleman's out of time. I want to now recognize the distinguished Chair of Education and Labor, Mr. Scott of Virginia.
Thank you, Madam Chair. I just want to get a couple of things on the record. First, the ranking member talked about the system allowed a single judge to set aside rules and regulations, and that's true as part of the system. It's also part of the system, as Mr. Weinbrink pointed out, the appeal is part of the process. Not only did the administration switch sides, they also essentially suspended the appeal altogether while the rulemaking. That's not part of the system. You should have a full decision. Second, Mr. Weinbrink, I think we heard that if you're a salaried employee and showed up 1 hour during the week, that you could get your full salary. Is that right?
It's more complicated than that. My friend is correct that if a salaried employee works under 40 hours, she could still get the full salary. It's not quite as cut and dry as that.
If somebody showed up an hour for the week, they'd get fired, isn't that right?
Sure, and the other thing to keep in mind, Mr. Chairman, is when these salaried employees don't work a full week, which is very rare, they're running their leave time. They're having to take sick time or vacation time. It's not as if it's just free. They're using
I just
their
wanted
leave
to make
time.
the point that if somebody shows up an hour a week isn't going to get the full salary. Ms. Chairhouse, the Department of Labor in 2016 did some evaluations. We've heard about higher education. For example, many people in higher education are already exempt, like teachers, coaches, department heads, and things like that. Did they calculate that about less than 4% of workers in college would be affected by the rule, and most of those don't work overtime anyway, and that the effect on payroll would be about 0.02%?
Yep, I think that's really important. Community colleges, four-year colleges, the vast majority of their staff are teachers, and they are exempt from this entire discussion. Research universities may have postdocs who are researchers who don't do any teaching that may be affected. Asking big research universities to pay their PhD employees $50,000 a year is, not an overreach.
And for nonprofits, less than 1% of nonprofit workers are both directly affected and regularly work overtime. Is that right?
Yep. Yes.
And that for small businesses, the estimate was that the effect on payroll would be less than 1%.
That's right.
Okay. Now, one of the things about the exemption is that it's for bona fide executive, administrative, and professional personnel. This administration's level, 15% of the people would be covered by that. How likely is it that somebody who's making less than 85% of salaried employees is actually a bona fide executive, administrative, and professional personnel?
No, that's a really good point. So one of the issues is the duties test is so weak that somebody can be classified as executive, administrative, or professional if they spend 99% of their time actually doing non-exempt duties. And so the salary threshold is really important in that case to make sure that workers who are doing a ton of non-exempt duties aren't getting taken advantage of if they're being paid really low
I
salaries.
think we heard somewhere along the lines that if you are not exempt, that you have to be reclassified and paid as an hourly worker rather than a salaried worker. Is that true?
It's absolutely false. There are millions of salaried workers in this country who get overtime when they work more than 40 hours a week. There is nothing in this rule that says you have to reclassify salaried workers
But
as
if you,
hourly.
so if you're not exempt and you're entitled to overtime, it would just be a prorated based on your salary. Now, Mr. Weinberg, you kept talking about people working more than 40 hours a week. If they are not exempt, they get paid time and a half. Is that right?
That's correct.
And if they are exempt, if they work 10 hours extra during the week, how much more do they get paid?
They get paid zero.
I mean, not time and a half.
They get paid nothing. A salaried employee just gets no pay for their extra work.
Now, does that extra work that's not paid for have to be executive, administrative, or professional?
To Dr. Schierholz's point, it generally is not. It's generally the reason that
They just work whatever hours they work. They could be stocking shelves for those extra
Sure.
hours, but you do not have to be either taking advantage of the executive, administrative, or professional exemption, but the extra hours do not have to be executive, administrative, or professional.
They generally are not, correct.
Thank you, Madam Chair.
Thank you, and thank you all for your testimony and for your questions as well. I want to remind my colleagues that pursuant to committee practice, materials for submission to the hearing record must be submitted to the committee clerk within 14 days following the last day of the hearing, preferably in Microsoft Word format. The materials submitted must address the subject matter of the hearing. Only a member of the committee or an invited witness may submit materials for inclusion in the hearing record. Documents are limited to 50 pages. Documents longer than 50 pages will be incorporated into the record via internet link that you must provide to the clerk within the required time frame. Please recognize that years from now, that link may no longer work. Again, I want to thank the witnesses for their participation today. What we've heard is very valuable. Members of the subcommittee may have some additional questions for you, and we ask the witnesses to please respond to those in writing. The hearing record will be held open for 14 days in order to receive those responses. I remind my colleagues that pursuant to committee practice, witness questions for the hearing record must be submitted to the majority committee staff or committee clerk within 7 days. The questions submitted must address the subject matter of the hearing. Before recognizing the ranking member for his closing statement, I would ask unanimous consent to enter the following materials into the record: the National Employment Law Project's comment letter opposing the Trump administration's 2019 proposal, a 2016 letter from over 200 college and university professors in support of the 2016 rule. Without objection, I now recognize the distinguished ranking member for his closing statement.
Thank you, Madam Chairwoman, and I do agree with you. This has been a very enlightening session. Let me begin by asking unanimous consent to place in the record letters from the following organizations expressing concerns with the Department of Labor's 2016 overtime rule: the American Hotel and Lodging Association, College and University Professional Association for Human Resources, and the Society for Human Resource Management.
Without objection.
Thank you. So what this is really supposed to be all about are the people in America who work for a living. And sometimes in Washington, we forget them. we start thinking about things other than what this law is really aimed at doing, and that is protecting and helping men and women that work every day, yeah, for a paycheck, but they do a lot of things for everybody in this country. And America wouldn't be America without them. And so this law was designed to help them. When we don't do anything about it, when we wait years and years and years before we change the threshold, we're not helping them. So what we had was, prior to the Bush administration, a long period of time, nothing. Then at least the Bush administration took a responsible action. And then we had years again when we didn't do anything. And what the Trump administration has done is dealt with this expeditiously. That's what's in the best interest of the workers of America. And remember what we were talking about earlier. Some of these people that we tried to reclassify did not want to be reclassified. They were angry at being reclassified, and no one listened to them. No one paid them any attention. There were real costs here. The University of Alabama provided information in my office that said it would cost the University of Alabama $15 million. And they put their decision-making in really stark contrast for me. They say, do we raise tuition to cover that? Or do we cut back on the services that $15 million represents? Either way, we hurt the students at the University of Alabama, and that's just one example of many, many universities and community colleges that we heard from. So I think sometimes we get up here and we debate these things in the ether, and it's not where things really matter. They matter out there in the many, many workplaces in America. My district doesn't have a lot of large companies in it. We have mainly small to medium-sized companies. And that's where most of the people are employed. That's where most of our workers work, not just in my district, but around America. And we oftentimes forget that's who we should be thinking about, the workers at those small companies. Yes, workers at universities. Yes, workers at nonprofits who are going to be terribly affected in a very terrible way by the Obama rule. What the Trump administration has done has been a responsible effort to help the workers of America. And I am deeply grateful that they have done that, and I hope they will continue to do that, and I hope future administrations will do so as well. With that, Madam Chairwoman, I yield back.
Thank you, Mr. Byrne. I now recognize myself for the purpose of making my closing statement. As we've heard today, over the past 40 years, the federal government's failure to adequately update the white-collar salary level has weakened overtime protections for millions of workers. These weak protections have made it all too easy for salaried workers to be denied the overtime protections to which they are entitled. In fact, as one of our witnesses testified, some employers are building a business model based on weak overtime standards by loading up salaried workers with excessive hours, with no overtime pay, and leaving other workers with too few hours. As we've heard, the Obama rule would have provided millions of workers with new or strengthened overtime protections. The 2016 rule would have also made it easier from employers to properly classify which part of their workforce is eligible for overtime protections and decreased employers' exposure to costly litigation. Rather than defending the Obama-era overtime update in court, the Trump Labor Department issued a proposal that falls well short of what workers deserve. And because the Trump administration is using the same flawed approach used in 2004, we do not have to speculate what will happen to workers. We know that this proposal will leave too many workers with less money in their pockets and less time to spend with loved ones. I urge the department to abandon its current efforts and defend the 2016 rule in court. Democrats stand ready to protect workers where the administration fails to do so. The Restoring Overtime Pay Act, H.R. 3197, would codify the strong salary threshold set in the 2016 final rule and require automatic updates every 3 years to ensure the level remains in line with overall increases in workers' wages. I note the department does currently have authority to do so. Growing income inequality and the declining power of workers have only reinforced the need for strong overtime protections. restoring workers' access to strong overtime protections, raising the federal minimum wage, and protecting workers' right to join a union are the pillars of federal efforts to give hardworking Americans a raise. We must all work to build an economy that works for all Americans, not just the wealthy few. Again, I want to thank all of our witnesses for their testimony today. If there is no further business, without objection, the subcommittee stands adjourned.